Hello and welcome. Thanks for joining us for this session on Gmp Equalization. This is part of the Mayor Brown Annual Pensions Conference, which is a series of webinars covering current and upcoming topical matters relevant to the pensions industry. I'm Ian Wright. I'm a partner and co-head of Mayor Brown's pensions practice, and today my colleague Giles Bywater will be joining us, who is also a partner in our pensions practice. Together we're going to cover where we are on Gmp Equalization since the Lloyds court case and what's coming up, recognising that we are still waiting for certain decisions, and therefore this is where we are today and not where we will necessarily end up. On that basis, let's get started. Today we're going to cover the background in terms of where we are now and what we do know, and we're going to look at two alternative methods of equalising. Method C2, which is the default legal position, which is year-by-year adjustment, and then look at method D2, which is the one-off adjustment, which deals with GMPs forevermore.
Thank you, Ian. It's been 2 years since the first Lloyds judgment in 2018, so we thought we'd start by providing a bit of background to the Lloyds case and what's been happening since 2018. Starting with the real basics. What's a GMP? GMP is a minimum benefit that's intended broadly to replicate what a member's benefit would have been under the additional state pension. So the member is no worse off as a result of contracting out. GMPs accrued from 1978 to 1997, so over a maximum period of 19 years. It's important to remember that GMP is part of the scheme benefit. It's not additional. So a member with a GMP will have a total scheme pension that comprises both a GMP element and an excess benefit element. This has implications because the GMP element is likely to increase in deferment and in payment at a different rate to the excess element. Why are GMPs unequal? Well, put very simply, men and women have different ages from which GMP is payable, 65 for men, 60 for women. This meant that GMPs accrued more quickly for women than for men. Drawing all of this together, if a man and a woman left a pension scheme with the same total scheme pension, the split between the GMP and excess benefit would be different for the man and the woman. This means that the total scheme pension would grow unequally over time because the revaluation rates and the increase rates would be different. It wouldn't be a proper legal webinar without some reference to case law, and we've squeezed it into this slide. So looking at some case law relevant to Gmp equalisation, the starting point really is the Barber judgment, a European Court of Justice judgment on the 17th of May 1990, which established that occupational pension schemes have to provide equal benefits between the sexes. And that applies to service from 17th of May 1990. Also, we have the earlier European decision in Deferred, which had established that state pensions do not need to be equalised. The uncertainty over Gmp equalisation, which existed until the Lloyds case, stemmed from the fact that although GMPs are part of occupational pension scheme benefits, they are designed to replace a state benefit. Now let's get stuck into the Lloyds judgment that was handed down in October 2018. There were two key questions that were put to the court. Firstly, whether the pension scheme trustees were obliged to equalise benefits for the effect of unequal GMPs, and secondly, if they were, what was the appropriate method for dealing with Gmp equalisation? On the first question, the answer was yes. Trustees are obliged to equalise benefits for the effect of unequal GMPs. That obligation applies to the period from 17th of May 1990, that's the date of the Barber decision that we mentioned earlier, through to the 5th of April 1997 when GMPs ceased to accrue. So the obligation is relevant to a maximum of 7 years out of 19 years of GMP accrual. So to put it another way, the majority of years of GMP accrual don't need to be equalised. As a result of the judgment, trustees are obliged to correct not only future benefit payments to the extent that they relate to GMP accrued between 1990 and 1997, but they also need to look back and correct past underpayments of benefits. And Lloyds decided that there needed to be interest applied to those arrears at a rate of interest at 1% over base rate. Having decided that the trustees did have to effect GMP equalisation, the court then went on to consider the second key question, which was what was the appropriate method for undertaking GMP equalisation. The court looked at 4 different methods. Method A was the most generous method. It involved each unequal aspect of benefit being equalised separately. Method B involved providing the better of a male and female comparator each year, so it's based on a year-by-year review. It requires dual records. Method C is really an extension of Method B, but it also provides for accumulated offsetting. What do we mean by that? We mean that if the favoured sex changes from one gender to the other, which is referred to as a crossover point, you can offset gains in years prior to the crossover point against future divergence. Method D involves equalising the value of expected benefits at a particular point in time. It's a one-off calculation. The court decided that there were a range of methods which were permissible, but most of them require the agreement of the employer. The only method which doesn't require the agreement of the employer, and it's referred to, as Ian has already mentioned, as the default method, is method C2. The difference between C2 and C1 lies in interest. When you're offsetting accumulated prior gains, under C2 you can allow for interest on those gains. C1 you can't. Method D had 2 varieties which were considered by the court, D1 and D2. D1 the court didn't like very much. D2 the court decided was permissible because it involves Gmp conversion under legislation. That was the important fact. It was available under legislation. Under that, GMPs are equalised and converted into ordinary scheme benefits. What we're seeing in practice is trustees and employers are considering either method C2 or method D2, and that's why we're focusing on those 2 methods in this webinar. So that's the Lloyds case in a nutshell. But what's happened since then? Well, we had a further High Court judgment just after the original judgment in December 2018 that provided some clarification on the operation of method D2, which doesn't require benefits to be first equalised using method C2 or in fact any other method. We've also had the DWP Statutory Guidance on Gmp Conversion as a method of GMP equalisation that was issued in April 2019. There's been no indication of any plans for the government to issue further guidance on GMP equalisation. We've also had Hmrc Guidance on tax issues arising out of GMP equalisation. Some very helpful guidance there. Just in relation to GMP equalisation, doesn't veer into GMP conversion, and we'll come back to that later in this webinar. Also, PASA, the Pensions Administration Standards Association, has established a GMP equalisation working group which has produced some very useful guidance on various aspects of GMP equalisation. All those items of guidance are available on the PSA the PASA website, and they provide good practice industry guidance to schemes which are facing GMP equalisation. So I would recommend that you have a look at those guides. That brings us up to date with what we know now. Looking now at what might be coming down the track. First of all, we've got the next instalment of the Lloyds case on the treatment of past transfers out. In particular, we think this is going to cover whether trustees who've underpaid transfers out as a result of failing to equalise are protected by a discharge in the CETV legislation or perhaps a discharge under scheme rules. We know that there have been further hearings on this matter which have taken place in May and October of this year. What's not known is when the judgment will be handed down, hopefully before Christmas. Also, we should be getting some guidance at some point from Hmrc in relation to the tax issues arising out of Gmp conversion. This really is a key area which we're going to come back to later on. And finally, probably more out of hope than expectation, we mentioned the Gmp Conversion Legislation. There are some areas which are unclear in that legislation, and hopefully we might get some clarification of those issues in the future. A lot of schemes started out after the Lloyds judgment in 2018 by taking a wait-and-see approach to Gmp equalisation, so waiting to see whether there are any further developments before getting stuck in. And what they had in mind is things like government guidance, Hmrc guidance, further court judgments. But now, 2 years down the line, a lot of schemes are getting stuck in. And I think there's an increasing awareness that although in most cases the adjustment amounts involved in Gmp equalisation are going to be relatively small, in some cases they could be significant. In the last few weeks, the administration provider XPS has been quoted as saying that the top 5% of pensioners who've been underpaid as a result of unequal treatment are owed on average £10,000 each, and some could receive as much as £25,000. And the average age of this group is 80. So it can be seen that there are good financial reasons now to be getting on with Gmp equalisation. What preparatory work are schemes doing? Well, the obvious item is finishing off Gmp Reconciliation and rectification work. What we mean by that is the process of checking scheme records against Hmrc records for GMPs and resolving any differences. We know that the end process for that is getting a closure scan from Hmrc, and there have been some delays recently in getting those scans from Hmrc due to the current COVID-19 situation, but that's still being progressed by schemes. In addition, preliminary data work is being undertaken, reviewing scheme data and identifying items which are needed for Gmp equalisation but which may not be immediately available. Also, use of equalised CETVs is becoming much more prevalent. That enables schemes to turn the tap off, if you like, for unequalised CETVs. So turning the tap off from producing further transfers out, which then may have to be revisited in the future. Next, we're going to have a closer look at method C2. Before handing over to Ian, I thought I just ought to explain the rather tenuous link between this photo of Usain Bolt and method C2. Usain Bolt, of course, holds the world record for 100 metres and 200 metres. He is a dual record holder. A scheme which adopts method C2 will also have to be a dual record holder, like Usain. They'll be keeping year-by-year benefit calculations on both the male and the female basis.
One of the challenges with method C2 is the administration side of things. It simply, can the existing administrators maintain dual records? And initially, administrators were very, very nervous about their ability to deliver that. Our experience is that they have got more comfortable with the ability to deliver what schemes need. And that's quite important because one of the other drivers initially that was making people think that they had to move to conversion was a concern about buy-in and buy-out. insurers were very, very nervous about this, and they have got far more comfortable with C2. And therefore, actually engaging with the administrators is an important issue for trustees, but most administrators are now comfortable dealing with dual records. The second issue is going to be passed on to payments. The court said there is no statutory limitation period here. That means, in principle, you're going back to 1990. That is a headache, not just from a can we do it, but also can we find the data that means we can do it. The court did accept that forfeiture provisions in scheme rules might be relevant, but it's very scheme specific. And even if trustees have the power to do so, they're going to have to think very hard about whether it is appropriate to do it. And they may well decide that there are different groups who trustees may find that they are minded to apply the forfeiture rule for different groups in different ways. And that's going to be a very scheme-specific and group-specific discussion. But it is one of those things that trustees will be wrestling with over the next year or so. The third issue is just whether trustees say, we stopped the clock. We had no idea we had to do this, and going forwards, we know we've got to do it, but looking backwards, we draw a line in the sand. Looking at some of the issues arising in practice, Hmrc is a major issue for both employers and trustees. Hmrc guidance is difficult, frankly. Their view is that increasing a benefit shouldn't constitute new accrual, which means that we don't have an annual allowance problem, and shouldn't cause members to lose LTA protection. And the logic for that is that it accrued way back in the day, pre-2006. However, for deferred members, if we get this wrong, it will blow up, frankly. Protection, and similarly for pensioners. And therefore, the Hmrc guidance on C2 is very helpful in that they've said we are not going to look back at what happened in the past. For pensioners, it gets really complicated because we could have pensions reducing, albeit that arrears should actually, on the ground, make up for reduction. But it does mean very careful communication because pensioners will not be expecting to reduce their pension. It's going to be hard on the ground, and administrators are going to feel exposed, frankly, in terms of having a script that explains very clearly what is going on and why.
Thanks, Ian. I'm now going to have a closer look at method D2, which involves Gmp conversion. But first of all, it's time for another tenuous link. Here is a photo of an MG sports car, which was made in the 1970s, and if you look closely at the photo, it is a convertible. This, of course, is very similar to Gmp, which was also made in the 1970s. It was created in 1978, as I mentioned earlier, and which can also be converted under Gmp Conversion Legislation. So we really are doing our best to make Gmp look exciting. Anyway, on to method D2. Gmp conversion is an option that was created by legislation. We're discussing it in the context of Gmp equalisation, but it can equally be operated outside that context. For example, members with Gmp which accrued before 17th of May 1990. As I mentioned, it's a statutory framework. Provisions are set out in the Pension Schemes Act 1993. And what the legislation says is that an amendment of the scheme rules can take place in relation to a member, or by an earner they mean a member, so that it no longer contains the guaranteed minimum rules. And Lloyds has confirmed that this can be used for survivors as well as for members. Gmp conversion can occur for all members who've accrued a Gmp, or just some of them, or even just one of them. So it can be used as a bulk tool. We can do a large group of members in bulk, or you could do an individual member at retirement if you wanted to approach it that way. If Gmp conversion is being used for Gmp equalisation, it can only be used for future benefit payments. An alternative equalisation method is going to be needed to correct past underpayments of benefits, and most schemes are using method C2 for that purpose. The Gmp conversion legislation sets out 5 conditions that have to be met. First one is that the replacement benefits, the post-conversion benefits, have got to be actuarially at least equivalent to the pre-conversion benefits. Equalisation is achieved as part of the calculation of the pre-conversion benefits. Condition 2, if the pension's in payment already, so for pensioners, the amount in payment can't be reduced. It can be reduced for deferred members, but that would require careful explanation in the communications. Condition 3 is that you can't replace pre-conversion benefits with post-conversion benefits that include money purchase benefits, except to the extent that they were already provided before the conversion date. Condition 4 sets out a minimum level of survivor benefit that has to be provided post-conversion. And Condition 5 sets out some procedural requirements, including member consultation and obtaining employer consent. Looking now at some issues which we're seeing arise in practice with method D2. Firstly, the annual allowance. The nub of the problem here is that the annual allowance regime, it predates Gmp conversion, and it's becoming increasingly clear that it didn't anticipate Gmp conversion. Whereas the annual allowance regime for defined benefit schemes focuses on the annual rate of accrued pension, not the actuarial value, the Gmp conversion legislation focuses on maintaining actuarial value before and after conversion. So what this means is that if you are reshaping benefits as a part of Gmp conversion, and this results in an increase in the annual rate of a deferred member's accrued pension, then this could have annual allowance implications for that member, even if the actuarial value of the benefits is the same before and after conversion. This could create possible unexpected annual allowance charges for deferred members. Another aspect of the annual allowance which we're seeing arising is the deferred member carve-out. Deferred members are largely excluded from the annual allowance regime under this deferred member carve-out, or DMCO as it's sometimes called. And what this means is that the revaluation of deferred pensions will not generally count towards the annual allowance. But the protection of the deferred member carve-out can be lost, and in the context of Gmp conversion in particular, if there are changes being made to the benefit design post-conversion, then some careful thought is going to be needed as to what the knock-on effects could be for the deferred member carve-out. Looking now at lifetime allowance, The issue here is lifetime allowance protection. There are various types of lifetime allowance protection which are available to members. They've been made available by Hmrc over the years. And these can result in an individual's lifetime allowance being increased above the standard level. Now, the problem is that some of these protections can be lost if there is benefit accrual. And this could happen as a part of Gmp conversion if, for example, there's an increase in the amount of the accrued benefit for a deferred member, or an increase in the amount of the pension in payment for a pensioner. If this happens, the protection could be lost, and this could have very significant implications for a member who has uncrystallised benefits. On both of these areas, we don't have any Hmrc guidance yet, and we've mentioned this a couple of times already. There's no indication of when the guidance is likely to be published, and this is creating significant uncertainty in planning for Gmp conversion. The issues that we're covering in this slide are ones that stem from the Gmp conversion legislation rather than from tax issues. As we've already seen, Condition 4 in the Gmp conversion legislation requires the provision of minimum survivor benefits. What the legislation says is that after conversion, the survivor must be entitled to a pension of at least half the value of the pension to which the member would have been entitled, that's our emphasis, by reference to employment during the period of Gmp accrual. So it's clear from that requirement that what's envisaged is 50% of a hypothetical reference pension being payable to the survivor. But what's not clear is how that hypothetical reference pension should be calculated. This is important because you need to know what the requirement is if you're going to be sure that you're complying with that requirement when you effect Gmp conversion. The risk of not complying is that the pensions regulator could make an order declaring void the relevant conversion amendments. Another condition of conversion is obtaining employer consent in advance of conversion. And this makes sense really if the employer or employers that you're getting consent from are those who are the ones who are currently liable to fund the scheme. But the definition of employer in the legislation is very broad, and it potentially covers historic employers as well as current employers, so employers who have ceased to participate and no longer have a funding obligation to the scheme. This makes the process of obtaining employer consent much more onerous, potentially. We've engaged with the pensions regulator on this point, but we haven't achieved a successful outcome in terms of narrowing down the scope of this requirement. Finally, we've got member consultation, which is required as part of the procedural requirements in advance of conversion. That's condition 5 again. The DWP's statutory guidance has indicated that this type of consultation should be at a high level, doesn't need to go into great detail, but there does need to be a genuine consultation. So members have got to be given the chance to make representations, got to be given the right information to make representations, and then the trustees have got to consider the representations made. Clearly, there's going to be a balance between giving enough information to members that they can make representations and not overburdening members with too much detail. This is a complicated area, Gmp conversion, and providing too much information could be counterproductive. It needs to be remembered also that Gmp conversion represents a change to the status quo for members. It's a move away from the benefits which they will have been promised when they joined the scheme. So communication again needs to be managed carefully.
Thank you very much for listening.